Let's take a look at the process of mediation in Singapore. Joining us on Zoom is Fei Kee. She's senior mediator at the Tripartite Alliance for Dispute Management. Ms. Kee, thanks for joining us this evening. We just heard there that salary arrears and payment claims cases, now those have gone up. What other types of cases do you also see most often?
Besides salary-related claims, we also see wrongful dismissal claims. And these are the two main different types of claims that we see in TADEM.
As far as trends go, and in your experience, what would you consider to be some of the tougher complaints to mediate?
Challenging ones are those that are contractual in nature, meaning they do not follow their employment contracts. Sometimes commission-related types of claims are more challenging for us to mediate because it really depends on the industry and the nature of the terms used. Yeah.
Right. The mediation process itself, if you could explain that one to us, because okay, let's take the more common cases, such as, for example, wrongful dismissal. No one, very few people admit that they are in the wrong. If I'm dismissed, I'll say, you have no right to dismiss me. I did all the things you asked of me. And if I were the employer, I'd say, no, I don't think you did what I wanted, what I expected of an employee. So as a mediator, what do you do? What are the steps that you have to take to ensure that both sides, even if they do not agree, they go away, at least understanding that they have been heard and they're right, at least someone has given an ear to what they feel is wrong done to them? What is the role of the mediator?
Yeah, you have actually rightly pointed out, as mediators, we are a neutral party. We are not siding any, whether is it the worker or the employer. So our role is to guide both parties to work towards a common goal. That's to resolve their dispute effectively and fairly. And so for wrongful dismissal claims, it's actually very emotional, and it's really a challenge for us mediators to help to mediate. But we try to suss out the intent behind, the dismissal, and through our probing, through our line of questioning, it does help to bring to light the positions held by both parties, especially when they felt being wrong, especially when they felt that the dismissal wasn't carried out correctly. Then by drawing it out for them to see, whether they conduct the termination in alignment with the Employment Act, this will help them to assess their own strengths and weaknesses of the case.
I'm curious, at what stage or how do these cases finally come to your attention as a mediator? So how are you brought into the process? And secondly, some of these mediation cases can really drag on, can't they?
Yes, true. Okay, so for the first question, normally the cases are lodged online. If they cannot do online, they can get assistance of advisory advisors or officers who will help them to book appointments. And then once the cases are lodged successfully, it will be assigned to mediators through the system. So when we receive the cases, especially for, we will go through the claims and then we will verify the claims with the parties.
All right, this process of verification. So as an example, if I wanted to lodge a complaint against an employer or employee, whichever side of the argument I'm on, what would you advise me to collect in terms of, I suppose, evidence, or what list of things do I need to get ready before I approach you to ask for your help as mediator?
So for salary-related claims, the employees will need to provide documents like the employment contract, the salary payment records, or attendance records, especially if they are claiming for overtime payments. CPF statement is also helpful, especially if they do not have employment contract. Some companies do not issue employment contracts even up to today. So we have to rely on perhaps CPF statement to see, which are the correct company they lodge against. Correspondence with their employers like WhatsApp messages and emails also help to suss out the verification of the claims. As for wrongful dismissal claims, employees will need to provide the termination letter or the resignation letter, and also correspondence with the employer via WhatsApp messages and emails. That is also helpful for us to verify the claims. Of course, there's also the other area of maternity-related claims, or where you can include certification of pregnancy and birth certificates.
Oh, thanks so much for spelling out these very difficult processes for our senior mediator Fei Qi there from the Tripartite Alliance for Dispute Management.